Donald Trump's lawyer is presenting a theory on when politicians can be sued for defamation, and arguing that the president's sexual assault denial is political speech, outside the reach of defamation law. The theory was outlined in court papers on Tuesday, in an ongoing lawsuit by Season 5 Apprentice contestant Summer Zervos. She alleges being forcibly kissed twice in 2007 and attacked in a hotel room by Trump. Zervos is suing over Trump's denials during the heat of his presidential campaign, including a statement how allegations from many female accusers were 100% fabricated and made-up charges, pushed strongly by the media and the Clinton campaign. Trump wants a New York state judge to stop the lawsuit on constitutional grounds by arguing the Supremacy Clause bars state lawsuits against a sitting president. But if that argument doesn't work, Trump's lawyer is also asking the judge to take a fairly broad reading of the First Amendment by holding that whatever he said isn't defamatory as a matter of law. Trump's memorandum in further support of a motion to dismiss reads, Ms. Zervos cannot hold the president liable for engaging in political speech in the context of a public debate, because such speech is clearly protected by the First Amendment. Political statements in political contexts are non-actionable political opinion. Trump's denial of committing sexual assault happened after the release of a bombshell video showing him boasting to access Hollywood's Billy Bush about grabbing women. The video ignited a firestorm. As Trump denied any misbehavior, several women, including Zervos, came forward to identify themselves as victims. Trump issued more denials and even threatened to sue his accusers once the election was over. Trump never did sue, but he's now defending himself in court and presenting his statements as part of a back-and-forth public debate, even if the discussion over sexual assault hardly touched on any area of public policy. Trump's attorney, Mark Kasowitz, writes, "This is a politically driven action brought against a sitting president for exercising his First Amendment right to speak on political and public matters concerning, among other things, his own qualifications for president, the media's role in the election process, and the tactics of his opponent, Hillary Clinton." Kasowitz then puts forward the Trump theory on when politicians can be sued for defamation. As a matter of First Amendment principles, courts shelter strong, even outrageous political speech, which the audience would reasonably view as part of a free political discourse rather than defamatory. However, there are limits to the wide latitude campaign speech is given in defamation cases. For example, a candidate's specific false allegations of criminal conduct might not be protected, as the cases Ms. Zervos cites demonstrate. But this case does not come anywhere close to that. Here, Mr. Trump was merely defending his character and qualifications for office from the false attacks Ms. Zervos leveled against him just a few weeks before the presidential election. So, in layman's terms, Trump says if a candidate falsely accuses someone else of criminal conduct, that's not protected. However, Trump essentially says if a candidate denies criminal conduct because sexual assault is against the law, that's political opinion. For more analysis on this story, head to THR.com. For The Hollywood Reporter News, I'm Tiffany Taylor.